It is my pleasure to welcome you this afternoon. I am Leslie Gerwin. I'm the Associate Director of the Program at Law and Public Affairs. And it is really my honor for several reasons to be able to introduce today's speaker. Nancy Morawetz is the Director and Founder of the Immigration Rights Clinic at NYU Law School, where she serves as a clinical professor. And while there are several reasons, there are two in particular that make me particularly delighted to be here. The first is because of the important work she is doing and the impact she's had in a field that has not been particularly friendly to law or attractive to lawyers. I know this personally because I recently attended my 30th law school reunion. My classmates and I were products of the 70s and the 60s even, and we set out to improve the world by bringing legal services and seeking laws to protect those who needed it but could not afford lawyers. Some of my most admired classmates have never given up this struggle, which means that the majority of them have now gone into immigration work, and they are following the lead of Nancy Morawetz. They are reading her must-read legal publications and benefiting from the major victories she has achieved on behalf of immigrant clients in litigation, as well as in her advocacy for legislative and administrative changes. The second reason is because of the descriptions of Professor Morawetz by those who have recognized her work. One award speaks for itself. She is the recipient of the Albert Podell Distinguished Teaching Award, which recognizes the outstanding achievements of faculty at New York University Law School. But another is the prestigious LexisNexis Matthew Bender Danielle Levy Memorial Award, which is given annually to the individual who has contributed the most to the field of immigration law. The Matthew Bender Vice President who presented the award stated, "Not only is Nancy one of the nation's foremost scholars in the field of immigration law, she works to deliver that legal thinking to those who need it most through her pioneering clinic." Now, one might expect the superlatives from an award presenter, but one of the law teachers' blogs, essentially Professor Morawetz's colleagues, reported her award by noting that Nancy is a super scholar, teacher, and person. She is a summa cum laude graduate of Princeton University, a graduate of New York University Law Schools, where she was editor and chief of the Law Review and a Root Tilden Snow Scholar. After clerking for Judge Patricia Wald of the United States Court of Appeals for the District of Columbia Circuit, she embarked on a career of legal service, first at Legal Aid Society and then at NYU. Professor Morawetz has described her mission as combining the work of the novice, her students, with the power of the experts, herself and her colleagues. In doing so, she has not only educated and served as a role model for young lawyers, as well as served individuals most in need of legal assistance, but she has also served the law, helping to move it closer to being an instrument of justice and compassion. It is therefore my honor to welcome Nancy Morawetz back to Princeton.
So thank you very much. That felt very undeserved, but it was very nice to listen to. One of the great things about the job I have now, where I teach a clinic at NYU Law School, is that I work with incredibly wonderful and dedicated students, and so and I'm delighted by all that we accomplish. But it also means that a lot of things wind up having my name attached to them, which really are the work of the students who I work with, who are so terrific. So what I want to talk about today is really how we are at a moment when, you hear a lot about comprehensive immigration reform. You hear a lot about an administration that is supposed to be friendlier towards immigrants. And yet I think we are at a critical point in which we are about, as a country, to embark on an experiment in immigration enforcement that's similar to mass incarceration and what we've seen in the criminal justice field. There was a time I remember when mass incarceration was just starting, and when I heard one of my colleagues speak about it, it was about, 15, 20 years ago. He handed out some chart, and people could see how the numbers were increasing, and it just seemed unbelievable how many people were in prison. And yet you couldn't believe that this would keep on going. And in fact, it was the beginning of what became a huge and disturbing part of American criminal justice. And we're actually at a stage in which something very similar is happening with the immigration system, the system of deportation and detention for immigrants of all sorts of different statuses. We've gone from a system in which about 5,000 people at any one time were detained back in about 1994 to that being 19,000 people in 2001, 32,000 by the end of 2008, and the number is just going to keep climbing. And that's the number of beds, the number occupied at any one time. In fact, there are about 400,000 people passing through the detention system every year. And the numbers deported similarly have climbed and climbed and climbed, so that just as you've seen the number of beds double between 2001 and 2008, so have the number of people deported. And the reason why this isn't just sort of something we've come to and we should expect it to recede is there are two things. One is that nobody in Congress wants to be against enforcement. And so everybody seems to think, or on both sides of the aisle, that it's a good thing to keep expanding the capacity to detain people. And so that number of beds has continued to rise. And one thing we know about immigration enforcement is that if the beds are there, they will be filled. And the second thing is that the systems for feeding people into this immigration system are becoming more systematic. They are catching more and more people with more and more minor reasons for being in that system. And in particular, and I'm going to talk a lot about the intersection of the criminal justice system and the immigration system, there's a system that goes by the name Secure Communities, which is patterned after what was called the Criminal Alien Program. And one thing you should know in this business is that labels tend not to mean what they seem to say. But that system for basically picking up any non-citizen who goes through the criminal justice system, even if that's because of a broken taillight or even if that's because of a relatively minor arrest for somebody who's lived here legally for their entire lives. That system is becoming very efficient, and it is identifying more and more people, and it is a priority of this administration to expand that system and make it operational nationwide by 2012. And so that's why I think we're at this very, very important moment, an important moment for saying, what is it we're doing? Does it make any sense? And what is it that each actor in the system could potentially be doing? And I'm going to be talking about the official actors, the Congress, the courts, the executive, but I actually think it's every actor, so it's everyone in the room. I'm sure all of you could do something that has to do with this system. So let me begin by talking a little bit about who's subject to deportation and detention. And I think that like any system of enforcement, you have to look at two things. One is you have to look at the official rules, and then the second thing is you have to look at enforcement. And just to give an example of the disparity between the official rules and the way we think the rules are actually applied, an example that became very important for immigration reasons in our clinic over the last 2 years, where the system on the criminal justice side, the system in New York for when somebody has a traffic infraction or a violation of an administrative rule. The official law is that if you pass on the right on a highway in New York, you can go to jail for 15 days. The official rule is that if you sleep on the subway in New York, you can go to jail for 15 days. Now, we all know that doesn't really happen. So when we're dealing with the criminal justice system, we see that a rule like that, and then we think, well, the patrol officer won't really apply that unless it's appropriate. The prosecutor isn't really going to seek that kind of a penalty, and the judge isn't really going to impose it. So we live in a system of criminal rules and sub-criminal administrative rules where we see the rules, but we don't really expect them to be fully enforced. And so there can be that disjunction. On the immigration side, what happens is that you have the rules, and if you have a system that puts somebody, that identifies the person and gets them started in the immigration removal system, and I'm going to talk a little bit about what those systems look like, there's no getting out. And so what happens is that very first identification of the person means that you go to the maximum penalty, and it's very hard to stop that. And that's why systems of identifying people that look like, well, that's appropriate. We ought to know everybody who's passed on the right. We ought to know everybody who's slept on the subway maybe because that's something we've identified as against the law. Well, we don't really think that on the criminal side. We don't really want to identify everybody who passes on the right or goes 4 miles over the speed limit or whatever. But on the immigration side, it becomes a system that really is looking for everybody. And once it finds people, there are very few safeguards. So what are the laws that have to do with non-citizens and who's subject to deportation and detention? I would say that basically everybody who's not a citizen is potentially subject to deportation and detention. Now, who will actually face it is different. But if you look at the laws, they're very, very expansive. And so let me tell you a little bit why. First of all, there are about 11 to 12 million undocumented people in this country, and you probably hear the most about those people because they are the subject of efforts at comprehensive immigration reform. That population is made up both of people who've entered without inspection and of people who have overstayed visas. And I think it used to be roughly half and half. I think it's more 60-40 now, but that's a large population. Any one of those people, if identified, would be subject to deportation. Some of those people would have a claim to relief. For example, you could have somebody who overstayed their student visa. They are no longer in status as a student, but that person has married a citizen and has applied to adjust their status. That person could even have an employment authorization document from the Department of Homeland Security that's basically allowing them to work while they are pursuing their status because it takes time for it to go through. That person is officially identified as an undocumented person and could be put in removal proceedings. And in fact, people like that have been placed in detention and in removal proceedings when there was an interest in doing so. But everyone in that category generally, and of course there'll be a lot of people who have no route to a legal status, as well as people who do, is subject to being deported. Secondly, there are about 12 to 13 million lawful permanent residents, people who we think of colloquially as people who have green cards. It hasn't been a green card for decades, but people still call it a green card. So the people who are green card holders, it's a range of people. Some people came relatively recently. I mean, their family might have waited for a long time to get an immigrant visa to come here, might have sold all of their belongings, might have come as a lawful permanent resident. You'll have other people who came here on some other status and then have adjusted and become lawful permanent residents. You have some people who have been here, as I said, just a few years. You have other people who have been here 40, 50 years who are lawful permanent residents. There are people who have served in the military who are lawful permanent residents. About 5% of the American military traditionally has been made up of lawful permanent residents. Today there's an effort to help people in the military become citizens, but that's relatively recent. And so there are many, many veterans who are lawful permanent residents, and also people who've been here since they were one. There are people, it's a varied group of people. Now, for lawful permanent residents, how many are deportable? I guess, we don't really know, but you can look at the law in the books, and the law in the books is pretty expansive. So first of all, on the criminal justice side, for people who have ever had any kind of interaction with the criminal justice system, who have any kind of fine that they've paid for marijuana possession or any kind of other relatively minor thing that they have done in their lives, people it's pretty easy to fall into the web of people who are deportable. And the laws on who's deportable are generally made retroactive, so that it doesn't matter whether you were actually deportable at the time you pled to whatever you did or paid whatever fine. You can still be out there in the population, living your life, paying your taxes, not of interest to anybody, but you officially could be deportable. And I don't think anybody knows exactly what % of lawful permanent residents fit into that category. But I think it has to be a substantial number of people, just because the criminal justice system, pulls in a significant number of people, in the general population. So even though immigrants are known generally to have a lower crime rate than other populations, like any other population, you're going to have the person who at age 18 was stopped for one reason or another and has a conviction. And then there are all sorts of other grounds. I mean, the one that makes me think that virtually any lawful permanent resident could be put in proceedings, and this isn't one that's enforced, but it's on the books, is if you're a lawful permanent resident and you move, you're supposed to notify immigration within 10 days. And if you don't, you're deportable. People don't know that. And of course, that's not a rule that's usually enforced. It's a little bit more like the passing on the right. But it's one that can be enforced. And so at certain times when there's a lot of interest in enforcing the law against one person or another, it's one that can get pulled out and actually used against people. Abandoning your status. So if you're a lawful permanent resident, you've been here 30 years, there is something that happens, that affecting your family and your country of origin, and you travel and you get caught up in taking care of things or whatever, and you're out of the country for more than 6 months, and actually that they don't have to use that rule of the amount of time, you can be treated as having abandoned your status. And so when you come back, you can be placed in removal proceedings. And that's actually not so uncommon. And then, then of course, if you're a naturalized citizen, well, if you're a naturalized citizen, you're the safest person, other than people who are citizens at birth, but you still potentially can get into the system, and it does happen to people. If there is some question about whether there was some error in the naturalization proceeding, some error in the original lawful permanent resident proceeding that was the basis for then later becoming a citizen, people can remain vulnerable. So then the question is, who faces deportation in practice? I mean, what actually happens with enforcement? And enforcement is probably the biggest part of this, because if you're talking about a system that could potentially be targeting 16 million people or something like that, and it's actually processing a much smaller number of people, how is it choosing who it's going after? So let me begin with the people who are undocumented, the people who have either overstayed their visa or entered without inspection. There are a number of different mechanisms by which somebody can wind up being arrested. And some of these have changed over the last few years. So, for example, there were major worksite raids that were happening during the Bush administration, in which officers would go in and they would round everybody up, and a lot of people were, through, I think, some pretty heavy-handed tactics, coerced into giving up their immigration rights in order to not go to jail for a long time. Those have become less common with this administration. Another thing that will happen is that there's a targeting of people who have outstanding removal orders, which is called a fugitive operation team. And I don't know about you, but to me the word fugitive, I have visions of Harrison Ford, running away from the police, and it suggests a consciousness of being a fugitive. The Fugitive Operations Program targets anybody who has an outstanding order, whether they knew about it or didn't know about it. But that is a priority. That's been a priority. And what was happening was that there was a quota on fugitive operation teams. And so they would go looking for person A and couldn't find person A, and then they would arrest everybody they could find in that apartment or that area who was undocumented. So a lot of people were being arrested that way. And a lot of people continue to be arrested that way, although one of the things that's happened in this administration is that they no longer have a quota for each of these teams. And when those teams had to produce 1,000 arrests a year, the easiest arrests to produce were the ones of the people who were just living their lives and doing their work and so on, and not the people who were actually people who had these old orders. Another way that people continue to be put into proceedings is when they apply for some kind of legal status and they don't get it. And so with respect to the undocumented, somebody who applies to adjust their status based on asylum, or they apply they apply for some kind of family petition, and their application goes in and it's not accepted for one reason or another reason, and those cases can be referred over to start deportation proceedings. And that has actually increased, and as far as I know, there's been no change in that. One thing that's happening, which we've been paying a lot of attention to in our clinic, is that Customs and Border Patrol is starting to, instead of monitoring just the border and monitoring entry, which is the understanding of their mission in all kinds of official publications, and I believe because they are driven by the same desire to produce arrest numbers that the people with these fugitive operation teams were driven by. In an effort to find numbers, they're looking, well, what are some easy arrests for them? And so in the Buffalo sector of Customs and Border Patrol, which has, and in particular the Rochester station, which those of you who know a little bit of upstate New York geography will know that Rochester is about as far from the Canadian border as you can get on the upstate part of New York. The Rochester station has the highest number of arrests of any Customs and Border Patrol station on the entire northern border. So you might say, well, that's very strange. Are people swimming across Lake Ontario? No, what's happening is that the Border Patrol there is getting on trains. So when you take a train from California to New York, it passes by Rochester. So they just go down to the station, they get on the train, they go through the train, and they question people. They find people don't identify themselves as citizens or don't have the right documentation. They take them off the train and they arrest them and they put them into deportation proceedings. That is not, as far as I can tell, a priority, an articulated priority in any way, but it is in fact how, a substantial number of people now are getting arrested and put into deportation proceedings. But probably the largest way, that the greatest system for getting people into deportation proceedings, if they are undocumented and here in the country, is through the criminal justice system. And so through local police, local jails throughout the country, and through increased networks, increased sort of arrangements between the Department of Homeland Security and local police departments, local jails, local counties, there are systems whereby as soon as somebody gets arrested, they get screened to see whether they might be somebody who's deportable. And so if you are an undocumented person and you get arrested, we have this, in New York, we have what's called the Criminal Alien Program. It's very similar to this new nationwide program. We've had it for years, and what it means is if somebody's held overnight in our jails and they're undocumented, it doesn't matter if they were the one who went to the police and said, this happened and the police weren't sure who was responsible and they got arrested. Their lawyer can sort it all out and get the charges dismissed. It doesn't matter. Once they are identified, there is a detainer. Once there's a detainer, they get taken to, as soon as they're released, they get taken into the immigration detention system. And because in New York, and this is generally true of the Northeast, there are not a lot of detention beds up here, that person's likely to wind up in Texas or Louisiana or someplace like that fighting their deportation case. And when they're down there in Texas or Louisiana, there are virtually no lawyers. It is very difficult to communicate with anybody. It's very difficult to have anybody visit you, and your chances of fighting are really very, very poor. So that system, that criminal justice system, is a very, very big way in which undocumented people, as well as everyone else, gets into the deportation system. So how about people who have permanent residency status? How do they wind up in the system? One of the big ways is by traveling. It used to be, that if you traveled and you were a permanent resident and you came back into the country and it was a short trip, they basically treated you as though you'd never left. And so nobody was trying to figure out a whole immigration nobody was trying to evaluate your case. You were somebody who had residency and you showed your green card and you came back into the country. But it doesn't work like that anymore if you are somebody who's potentially deportable. And here, the thing that is a big, big trigger is if the person has ever had any kind of a criminal conviction. And so if somebody, so let me just give you an example. If you have one offense on your record for possession of a very small amount of marijuana, and you're a permanent resident, you're actually not deportable for that. It's the one exception on drug grounds for making somebody not deportable. If, however, under the law as it is interpreted and applied, if you travel, if you go to a family funeral, if you go on a trip, if you go to the other side of Niagara Falls, and you come back into the country, you are actually, that same permanent resident is now what they call inadmissible. And you are subject to removal because of that offense. And not only that, you're subject to detention, and you might or might not be eligible ultimately for some kind of relief from removal. So that's a huge trap for permanent residents, and it's a trap that people have tried to educate immigrant communities about, but a lot of people don't. People just frankly can't believe it. They can't believe when they've been living perfectly honorable lives for 20 years or something, that people often don't even remember these older convictions or violations, and they don't realize that we now have a data system that has everything integrated so that it's right there at the fingertips of the people who are at the border. Although that's a way that people wind up in removal proceedings. And I can't say exactly how many people that is, but I certainly see an awful lot of those cases. A second, which is similar to what I was saying with the undocumented, is having presented yourself in some way to the immigration authorities asking for something. So if you apply for citizenship and they decide not to give you citizenship, and they identify anything in your record that could be a reason for putting you in removal proceedings, you go into removal proceedings. So our clinic, for example, right now represents a woman who applied for citizenship. She was denied citizenship because of a 1985 conviction, and she's now in removal proceedings. And so that's not unusual. That's a very, very common story, and you can find it in the legal reporters. I mean, there are lots and lots of instances like that. Similarly, people with green cards now have to renew their green cards every 10 years. And at first, this was considered just basically routine, getting a new picture, a new set of fingerprints, things like that, just to have a better system of identification. It doesn't make sense for an identification document like that to have your picture from 40 years ago. And so it was treated just as a documentation issue. Now, at least in some parts of the country, it's being used as a new screen. Again, something where somebody will say, oh, well, you know what, you have that conviction from 1975, and that's a deportable offense, and so you are now going to be put into removal proceedings. And then people with permanent residency can be placed in removal proceedings because of other kinds of enforcement, so that things like worksite raids, which usually are considered a big issue for the undocumented, are also an issue for permanent residents because they can be, taken in, all their paperwork can be looked through, and then something that, goes way, way in the past winds up being a reason that they wind up in removal proceedings. And then again, there is the interface with the criminal justice system. So here, It's a little bit different from the undocumented if you are a permanent resident and you never are convicted of anything. For the most part, you won't be deportable. It's not completely true, but it's for the most part, if you haven't traveled. If you travel, then you don't have to have been convicted. If you have a Border Patrol officer who interrogates you and gets you to admit that drug use in your past or something like that, then they can actually put you in removal proceedings. But if you don't travel, if you're in the country, for the most part, it requires some sort of a conviction. And so, but, it can be a pretty minor conviction. Things like turnstile jumping are classified as theft of services. Theft of services is considered a crime involving moral turpitude. 2 of those and you're deportable. 1 of those, in a shorter time period and you're deportable. Again, drug offenses, minor drug offenses, very easy for you to become deportable. And so as soon as you're deportable, it's the same system. So it doesn't matter. You could have been here with a green card, working legally, supporting a family, and again, we have cases like this. You get arrested for something where you get the charges dismissed, but you have that old one from 10 years ago, you're deportable, you'll go right into that detention system. There will be a detainer. Or if you're convicted on a new offense, even if it's a minor offense, it can be something that makes you deportable. If you're deportable, what does that mean? It means that you, at least in New York, you go to their processing center on Varick Street, right on the way to the Holland Tunnel, for any of you who go back and forth to New York. And then from there to Texas. I get calls like that. I got a call last month, 2 Class B misdemeanors for marijuana, very minor sentence in the New York criminal justice system. This guy is sitting in Texas in detention without access to counsel, trying to fight his case. And so those things really, really do happen. Now, the criminal justice system for picking people up also winds up picking up citizens, and we shouldn't be surprised by that. And there are lots of cases, actually. Not hundreds of cases, but there are dozens of cases now that have been identified of citizens winding up in the system. And it's not surprising because, for example, there was one case where there was one document in the criminal justice file that suggested that a man was from, in this particular case, I think it was Honduras. Every other document said that he was from the United States, that he'd been born in North Carolina, and so on. But, somebody just saw that one document and said, oh, well, he must be a non-citizen, put him in proceedings, I think that case also went to Texas. It was a kind of it might not have gone to Texas, that one. But in any event, it's a mass proceeding in front of a judge. This guy was ordered deported. He was deported. And it took an enormous amount of work to actually bring him back to the United States. There was, and particularly people who get into the system with any kind of a mental health problem, can face big problems because they might say something at some point which leads somebody to think, aha, this person is not a citizen. And then, people will even sort of, sometimes advocates will fax over a copy of someone's birth certificate, and immigration will say, well, how do we know that's his birth certificate or whatever? And so the burden, in a sense, shifts. And there are stories, for example, there was this one case where, the way citizenship law works, it can matter a lot whether your parents naturalized before you turn 18 or after you turn 18. There was a guy who was in detention in Arizona for a year because whoever translated his birth certificate read the date as month, day, year, which is what the convention in the United States and the convention virtually everywhere else in the world is day, month, year. And that was the difference between being a citizen and not being a citizen. And he was in detention for a year before somebody sorted that out. So now let me turn a little bit to detention. Who's subject to detention? Everyone who is put in removal proceedings is subject to detention. Now, is everybody detained? No. Some detention is mandatory. So for any drug conviction, for example, detention is mandatory. For some people, it's discretionary. You can go in front of a judge. But some people don't have that opportunity, particularly a lawful permanent resident who returns from a trip. Because they are stopped at the border, they are not eligible to go in front of a judge to get out on bond. So you can sometimes get people out on bond through advocacy, but a lot of people wind up in detention. And actually, Border Patrol has now said it's going to increase its use of detention for people who travel just in time for the holiday season. Who is detained also very much is driven by bed space. The more space there is, the more people who are detained. And as I said at the beginning, the number of detention beds just keeps increasing. There's the agency is focused on more and more efficient use of its detention beds, and so there are operations called Operation Reservation Guaranteed, the language of the agency on making sure that there is a bed for the person who they want to detain. Now, detention is jail. It is often county jails, often jails with really awful facilities. It is spaces where, sometimes it's tent facilities, like there's a major tent city down in Texas. There are, there are no programs for people. And there are limited resources in the law libraries. There is no right to counsel. So you're arrested, you're detained, you want to prove that that birth certificate is the wrong way, but you're sitting in detention, you have very little access to somebody who can help you sort that out, and you just stay there until you get deported, unless you're lucky. And those in detention have the least access to lawyers. And they have the least access to lawyers because most of the detention centers are located in the places with the fewest lawyers. And we feel this particularly in New York because we have a relative abundance of lawyers, volunteer lawyers at law firms, pro bono institutions that provide legal services. If somebody's so we have the lawyers, but the people are not there. And even the people who are detained in New York, it's hard for them to get access to lawyers because it's a lot of work. It takes a lot of time to get into a detention facility. You don't know when your client might get transferred. You worry about taking on a case, and then your client is suddenly 1,000 miles away in front of a judge who won't let you appear as a lawyer by telephone. And so, it's a very difficult thing when people are detained. But even if you're ready, and there are institutions that are ready to represent people when they're detained, those institutions aren't where most of the people are detained. So I guess as I've talked through this, I've talked a little bit about what this means in practice. I think that it really means that who gets into the system really defines who is going to get deported. And a lot of that is because the laws are very unforgiving. Once somebody is tagged as somebody who's removable, the laws as they were restricted in 1996 by Congress in a sort of not very carefully thought through process don't really provide much opportunity for a lot of people. And so unlike the situation where you have that initial decision, well, should we use police resources with this person, and should we use prosecutorial resources with this person, and should the judge impose this sentence with this person, that system which, is very imperfect, but which we are familiar with from the criminal justice system. On the immigration side, once somebody is in the system, it's very, very difficult because it's not hard to prosecute these cases. It's easy in a lot of situations. It's easy to show that somebody who came in on a visa and has overstayed their visa so that they're a non-citizen, and if they're not eligible for some obvious form of relief, then the person, especially if the person's detained, they're going to agree to be deported. So it's easy to get a win that way. So prosecutors don't actually have a lot of incentive, although they have official policies. They don't have much incentive to actually exercise any discretion once somebody is in the system. And the people who are putting people in the system aren't really even told that that's part of their job to exercise that discretion. For particularly the people on the criminal justice side, they're just supposed to identify everybody who's potentially deportable. And so you have sort of an automatic feed into the system, and then you have no brakes on that by the people who prosecute the cases or the judges, except for those relatively small numbers of people. I mean, it's significant, but the people who are eligible for some form of relief. And the reason that I think we're at a critical time is that these automatic systems are expanding. The new system called Secure Communities, the agreements between the federal government and local governments, these what are called 287G agreements, are designed to identify more and more people. So if you identify more and more people in a system in which lots of people, once they're identified, are going to get put into the system, and then there isn't going to be a way to stop them at the end of the system, it's just going to grow. And the more detention beds there are, the more people are going to be put into this system. I have met recently and heard somebody from the administrations, when I talked about my concerns about growing detention, and I said, well, it's going to be 10 times the size. I was told, well, it won't be 10 times the size. I didn't find that to be a lot of comfort. Because I think it's growing, and I think we have to expect that it's growing unless something is really done to stop it. So why do I think this is a problem? A lot of people think this isn't a problem because they think, well, if you're going to target anyone, you ought to target people through the criminal justice system. That makes more sense than targeting people because they're riding a train or targeting people because of where they happen to live. And that has a lot of political traction. But it's a really dangerous thing to keep expanding the system based on the criminal justice system. And there are a couple of reasons. The first is that the laws are it's so incredibly overbroad who could be potentially in the immigration system that you wind up giving enormous discretion to the officer on the beat who decides whether to arrest someone. Because it's an incredible power to have. You arrest someone, they get screened, then they're in immigration detention, and you don't need to worry about them anymore. There's no accountability at the arrest stage. Secondly, the consequences are vastly disproportionate, so that we have a system that was put in place, a legal structure that essentially is like saying you go to jail for 15 days for sleeping on the subway. I mean, it is saying to a permanent resident who, might have served in the military, all their ties are here, all their family is here. It's sort of like this one offense and you get deported and that's it. And so when you have a system that's that vastly disproportionate, it's problematic how you go about putting people into the system in the first place. You want to be much more careful about that. Thirdly, I guess, when you're talking about the criminal justice system and convictions, which are what's so critical for permanent residents, and also for other people who want to adjust their status, where convictions can wind up being very, very important. The outcome in the criminal case really depends on the sophistication. Well, it depends in part on the sophistication of the criminal defense lawyer. And criminal defense lawyers are overworked, and they're not. Some are going to be very sophisticated, but many of them are not going to be. So that's there are still criminal defense lawyers who think, if you saved somebody a day or two in jail, that was a good deal. But if you saved somebody a day or two in jail and you led to them being exiled from the United States, that wasn't a good deal, especially if there was another deal that was available that wouldn't have done that. And so it's a real problem to have people identified this way when we don't have systems in place to make sure that defendants are properly advised. In fact, there was just an argument in front of the Supreme Court earlier this month where the question was whether criminal defense counsel have some obligation to figure out immigration consequences and advise their clients about that. And, I mean, I don't want to predict what will happen at the Supreme Court, but I mean, the court might ultimately agree that in that case, since the client was misadvised by his lawyer, he was told, don't worry about immigration consequences, that's a problem. But it's not totally clear that will happen, and it's not clear what the court will be willing to do. And so because there's a fear about creating too much of a burden on the criminal justice system, but in a sense, the criminal justice system is being asked to serve this incredible immigration role, and unless it takes on that responsibility, it's just very inappropriate to have it playing that role. And then, I think this system is a problem, as I've said over and over again, because it sends people all over the country where they don't have counsel, where they have no chance to fight their cases, because despite how broad the immigration laws are in terms of people being deported, they're not as broad as this administration or the Clinton administration or the Bush administration thinks that they are. And so, there have been, on the part of immigration advocates, 9-0 victories and 8-1 victories in the Supreme Court on, for example, how to classify offenses for whether they lead to mandatory deportation or non-mandatory deportation. And, so it's very important that people have an ability to fight their cases, have an ability to identify those issues, and if they are off wherever where they can't really make those legal arguments and have no one to defend them, they're not going to be able to do that. So what should be done? I guess this is taking me longer than I had predicted when so I'm going to talk a little bit about Congress and the courts, and then I'm mostly going to talk about what I think could be done by the administration. The first thing, in terms of Congress, Congress has a long history of, doing big things about immigration, and then on the side saying, okay, well, we're going to be tough here with this enforcement, or we're going to be tough on people who've committed crimes. There's always the image of the immigrant who came to commit crimes, which usually, you don't get a vision of a 1-year-old who came here and grew up here and then did the same thing as a lot of other kids, at the age of 18. But nonetheless, that person, everyone, from that person to the person who actually is coming into the United States to commit a crime, all those people wind up getting labeled as criminal aliens. And it's very difficult in terms of political will for Congress to not succumb to that label. And the pattern is that whenever there's a bill that has to do with immigration, somebody cuts a deal in which they make things tougher for people who can be labeled as criminal aliens. And the 1996 laws are a case in point. There were many, many things on the table. There was limited attention to what was happening with this set of rules. And there was ultimately a conference report which did most of the damage in the current law was done in a conference report. So it wasn't in the bill in the House. It wasn't in the bill in the Senate. It wasn't the product of a deliberative conference committee because that didn't happen. It was the product of something written by staff, a conference process that was so problematic that only one Democrat signed the conference report because people were so angry about it. It came out of that process. It got rolled into the budget bill in 1996, which was the year after Congress had shut down the government by not passing a budget bill. In 96, they weren't going to do that again. And so that's how a lot of this happened. And you would think that if it happened in that way and it had horrible consequences, it could be undone. And I think there are efforts to get people, as they're thinking about immigration reform, to realize how extreme the laws are that were passed in 1996, how unfair they are, and Congress could do something about it. It could restore some of the discretion that used to exist for immigration judges. It could cut back on the situations that tie the hands of immigration adjudicators by requiring detention when detention doesn't make any sense. It's not in anybody's interest. Congress could do a lot to oversee what the agency is actually doing. It could look at whether there are systems in place to provide incentives so that the people at the lowest levels of the bureaucracy are in some way get some feedback when they make mistakes like deport citizens and other things, and ways to prevent those kinds of things from happening. So that, if somebody's in detention for a year for no reason, somebody's budget feels that in some way. So Congress could create some of those kinds of systems. It could certainly do some of that through oversight. It could stop listening to reports about numbers of people deported as though that's always a good thing. And it could start looking for other kinds of information about numbers of children left in the United States without their parents, number of families losing their wage earner, and other things like that. I'm not very hopeful about all of that, but one likes to think that some of this could be done, particularly to stop the escalation of detention, which is an incredibly costly and wasteful system, both budgetarily and in terms of human lives. In terms of the courts, the courts could be doing a lot, but I don't really think that with the courts where they are today, they're going to do some of the bigger things they could do. But, the same week that Brown versus Board of Education was decided, a case that overturned decisions from the end of the 19th century, which were rooted in acceptance of de jure discrimination. That same week, the Supreme Court issued a decision that said it's perfectly fine to change the rules retroactively that will cause the deportation of somebody who's lived their entire life here, and that's not anything that the courts will review, that it was something that was just too entrenched once again because of decisions from the late 19th century, which are abominable decisions to read, but still remain the constitutional framework. I don't think the court today is going to do that, but they could be doing that. They could similarly be looking at the rules that basically say that your liberty doesn't matter if you're not a citizen. It's just fine. You can be detained if it will help you be deported. I mean, they could be looking back at things like that. So I will leave aside those unrealistic hopes for the courts, but the courts still can do things. I mean, for example, the courts can exercise jurisdiction in cases to the full extent of what really should be exercised in light of protecting people's basic liberty interests. So it is currently somebody has 30 days to petition for review, and you have people sitting in detention centers who don't get their mail until, I don't know, some later time, or they might not get the mail at all telling them that they've been ordered deported. That starts this clock. There's actually a case on petition to the Supreme Court right now that involves somebody who didn't get notice of those 30 days, and the court said, well, that's too bad. Your 30 days ran from the time of the decision. I mean, it's hard to believe that there are courts that say things like that, but they do. Just like the Board of Immigration Appeals says, well, you could have sent your appeal by overnight service, and the overnight service might fill out an affidavit saying that they failed to deliver it on time, but you should have sent it even earlier, and that's too bad. You're out of luck. I mean, they actually say that, and they actually do that. The courts could sort of read those kinds of rules more reasonably. They could read it more reasonably when people in detention depend on lawyers who might tell them that they are going to file an appeal and don't in fact file an appeal. The courts could be looking at those kinds of cases and making sure that they provide review. And the courts have been reluctant to do too much because they've faced an onslaught of cases. They have a huge caseload in the courts because the immigration cases go straight from the agency to the courts of appeals, the federal courts of appeals. So it's kind of crazy. It's a totally crazy system, and the courts are flooded. And so they don't really want all of these cases, but they could nonetheless exercise their responsibility to take all of these cases because they really play a crucial role in oversight of the agency. And if anybody does not receive notice of a removal order, I mean, it seems obvious that there has to be a route for them to be able to go to court. The courts could take, although the courts might not be willing to go back and look at some of these constitutional decisions that treat retroactive laws as being just fine and treat deprivation of liberty as not being a problem if it's in furtherance of removing somebody, they could nonetheless take the broader constitutional principles and take them seriously as they are construing statutes. And they have done that in some cases, so that, with respect to mandatory detention provisions, when the government came forward and said, well, we really only detain people for an average of 30 days, the Supreme Court took notice of that in its decision that said mandatory detention is okay. Well, now when courts are faced with detention, which is 6 months, 7 months, 8 months for somebody who's eligible to stay here but has to have a certain hearing first, the courts could say, no, this isn't really permitted. We're talking about somebody's liberty. We have to at least look, is this person a risk of flight, or is this person in some way a danger? There's a lot that courts could do in terms of providing due process access to counsel. They could look skeptically at records where people are detained, where they have no real right to counsel, at the fact that people are knowingly transferred from places where they could have counsel to places where they won't have counsel. There's a statutory right to counsel, and the government shouldn't be allowed to get away with basically undermining that right by moving people far away. And then, of course, there's lots and lots of technical things the courts can do, but I won't bore you with all of that, especially since you're not a legal audience. The courts can also provide back-end remedies when citizens are deported through tort remedies. They can provide remedies for improper detention, again, tort remedies. These are things that the courts can do and which would have an effect back on the system. And some of that the courts can only do if people bring the cases, and there aren't enough of us bringing the cases, but I think we are increasing in numbers. It's the executive branch that can really do the most, and I think the most important thing they can do is to change the culture of enforcement, and I think some of this might be starting to happen, but it has not happened in a truly in the kind of way that I think needs to happen in order to trickle down to the people in the field. Back in 2003, the Department of Homeland Security issued a report called Operation Endgame with the stated goal of removing all removable aliens. So that's like the 16 million people I was talking about at the beginning. And if that's and they had a strategic plan to achieve 100% removals. And so the systems that they've created at the border, with the criminal justice system, on the trains, all of that can be seen as the product of Operation Endgame and the culture of Operation Endgame. And I think what's critical is to change that and create the sense that, especially for an administration, which, like the administration before it, believes in comprehensive immigration reform, it's completely inconsistent to have an enforcement strategy which is to remove all removable aliens when the poster children of immigration reform are removable aliens. I mean, it doesn't make any sense to do that. And so what can be done to end the culture of Operation Endgame? I think the first thing is to remove numbers as a measure of success, which, as I mentioned, has happened with the fugitive operations teams, but I think can go through a whole lot of the rest of the system. I'm sure that there are performance measures all the way through, and we just don't know about all of them. We try to get them through Freedom of Information Act requests, but that's a very slow process. They can create operational requirements which require the justification for use of resources. If somebody is being detained, if my client picked up on a train in Rochester, is then detained for a month and sent to one prison and then sent down to Texas and then transported back to New York, that costs somebody a lot of money. And it's nobody's accountable for that. I mean, she's now out of detention, but nobody's accountable for that. Somebody ought to be accountable for wasting the taxpayers' money in that way. There should be an end to automatic feeds, these kinds of systems like in the jails or like on the trains where or at the airports, where people are just identified and then immediately put into proceedings. That at that initial level, the effort up there is to simply identify people with the assumption that you just put them in proceedings. The same with the person denied their naturalization application. And the system should be accountable for wrongful deportations. People should really be accountable for that, both for the cost of it and for the human tragedy that's involved. There can be a reassessing of priorities that don't just go by label like criminal alien, but priorities that really look at what is the impact of deporting somebody, what does it mean for that person's family, that recognize that we are operating in a system with no statute of limitations. It would be great if Congress put in a statute of limitations, but the agency could certainly administratively create a priority which effectively puts in a statute of limitations on when they will go after somebody to deport them. And then I think beyond the federal government, I'd just like to make a mention about localities which are now increasingly engaging in these efforts. They're either allowing the Department of Homeland Security to come into their facilities, or they are entering into contracts with the federal government. Those localities can insist on agreements that protect the rights of the people who live in their communities. They can insist on due process. They can insist that the immigrants from their communities not be transferred, that they be given a reasonable chance for a bond hearing in the locality where they are arrested. These are things that localities can do. And we've just seen, for example, with the 287G agreements, that the city of Houston insisted on some provisions and the Department of Homeland Security wasn't interested in them, and so they are not continuing their 287G agreement. Other localities can do that. In New York City, we're trying to get the New York City corrections system to stop serving as an automatic feed into removal proceedings, which has had such disastrous consequences for New Yorkers. So I said I would talk for about 40 minutes. I'm well over. But my basic message is that there's a lot to be done, and there's something that everybody can do, and but that the system very much needs to be fixed. And I'd be delighted to take any questions. Any questions? Yes.
I was wondering if you could talk about the politics of discretion stripping or jurisdiction stripping, why Congress has been tough on immigration by limiting the power of immigration judges and appellate judges to review immigration cases more than, my impression is that we do this more than we do for other types of civil penalty or that they really don't trust judges.
Yeah, well, it's a wonderful question, both why is there the stripping of power from immigration judges and also from the federal appellate judges. I think it's a mistake to assume a kind of logical unitary purpose to what Congress does, particularly in this area. You know, so if you want to know why was this law written this particular way, you'd have to talk to the staff members who happened to be in that room that wrote the conference agreement back in 1996, because whatever they wrote wasn't the subject of discussion by the committee members. It wasn't the discussion on the floor. And why did they do it? I believe they were the captive of people who just wanted to see a lot more people deported. And you know, I'll just give you some examples. You know, there's a rule that was added, you know, before 1996, if you were a permanent resident and you were put into what were then called deportation proceedings, you could seek relief and show your equities unless you had served 5 years in prison for what was classified as an aggravated felony, which was a relatively narrow group of crimes. So in 1996, what did they do? They said, well, the two houses said, let's change that from 5 years served to 5-year sentence, because they thought that, you couldn't start the proceedings until the person had served the 5 years. It didn't really make sense to wait until the 5 years were up. And what ultimately came out of the law, from the conference committee, was if you had any conviction that was labeled an aggravated felony, then you couldn't get relief from removal. And at the same time, they took the list of things that were classified as aggravated felonies and made it the most expansive, non-coherent list of offenses you can imagine. So that, if you read press accounts about this term aggravated felony, first of all, people assume it requires that it be a felony, and they assume that it requires that it be aggravated, and neither of those is true, because the labels don't mean anything. But people used to think, well, that must mean that you were sentenced to a year in prison. Well, not really. A couple of categories you have to have been sentenced to a year, but the sentence could have been suspended. In California, instead of probation, they use suspended sentences for a year. So suddenly all of those, for those categories, were being labeled as aggravated felonies. But then there are other categories where you don't have to have been sentenced to a day in jail. And there's a lot of misunderstanding about that. So you have this. So they did that at the same time that they said any one of those and no relief. So now what we have is a system where somebody can be eligible, permanent resident for 40 years, might have served in the military, come back disabled. I mean, it doesn't matter, that person, if they have one of these convictions that gets into this category, they can't get relief. So that's one thing they did. I don't think anybody was necessarily thinking that when they did both of those things at the same time, what would the combined effect be? Because you figure out those combined effects when you have hearings. You don't figure out those combined effects when you're doing it all at once. Then they had another thing they put in. They said, well, they said, we think people are delaying their proceedings to be eligible for relief. Because under the old law, if you had to have been a lawful permanent resident for 7 years to be able to get relief, but they kept looking at your time during proceedings. So people said, well, and you can see this in the House and Senate reports, we think people are delaying their cases to be eligible for relief, and that's not right. So there was the proposed legislation that went up to the conference said, if you have been, once you get your notice that you're being put in deportation proceedings, that stops your 7-year clock. But when the conference, they said, no, in addition to that, let's say that the clock stops when you committed an offense that would make you subject to, and this gets really technical, inadmissibility or deportability and so on. And now in the courts, and in a case that I lost in the Second Circuit, the court says you could have come in 1980, been convicted of an offense in 1982, had nothing since then, right? And your clock stopped for that relief back in 1982, long before Congress passed the law in 96. So, in my brief, I said, well, had other legal arguments, but in a sense, I was saying it doesn't make sense that in 96, Congress said the person who committed their offense, 14 years ago is somebody we're more concerned about than the person who did it yesterday. I mean, it doesn't make sense that Congress would have done that. But that was sort of the product of this thing they added in, and they added in a whole lot of different things at once. And that was how they took the discretion away from judges. So I don't really think there was a coherent theory behind it, except people who wanted the government to be able to deport more people. I don't think there is a coherent theory that supports all of these things as they come together. In terms of judicial review, there was a similar story, which you do see in some of the statements by senators and congressmen that people, immigrants are delaying their cases, and they're delaying their cases to stay here, and that's why they're appealing their cases. And so I think that was some of the force behind the cutback on judicial review. Was it true? Was it true about 1% of the cases or 5% of the cases? Nobody looked at that. There was absolutely no evidence that showed that there was, in fact, a real problem but it was a story, and it was a story that in the midst of lots and lots of different reform wasn't anything that anybody looked at very carefully. Now, as to judicial review, the courts came back and said, look, you just can't eliminate judicial review over everything. And then the system got even more complicated, and then we have the system we have now where some things are reviewable and some things are not reviewable. And maintaining that reviewability in the context of the reality that the courts feel so flooded is difficult. But it's not really a rational system. So. Yeah. Yes, you.
I have a question about the use of the immigration detention system as a system of prolonged preventive detention for terrorism suspects. The Obama administration has said it's not going to rely on the authorization of use of military force as a way to sort of continue preventive detention. But the Bush administration already started using the immigration detention system right after 9/11. David Cole has a long article this year saying that in 2002, 5,000 terrorism suspects were put in the immigration detention system. Even when they were cleared of all their immigration charges, they were still held there, and none of them were ever convicted of terrorism. I'm wondering, has the Obama administration done anything to reduce the use of the system, or is the Obama administration continuing this sinister use of the immigration detention system?
Well, I'm not sure I really know the answer to that question in terms of, is that being used to some extent in some parts of the country. It is certainly true that in 2001, that was a time when there was massive use of immigration detention as a holding place for people, and people were held not only after they were, had resolved their immigration cases and said, okay, deport me, but they were held even after FBI officers cleared them and said that they were of no interest to the government, and it required a very high level of clearance. And the system we have today is subject to exactly the same abuse. I mean, it's that system's in place. I don't think it's being used in that massive way today, but it's certainly in place to be used at any time, and that in itself is very scary. I mean, one of the things that's ironic on the issue of so-called terrorism detention is that Congress passed a statute that authorized some detention of people, pre-trial, anything detention of people seen as terrorism suspects, but put in safeguards for that. And as far as I know, no administration has ever used that system because it has safeguards. And so instead they've used the system that isn't really meant to be used for that, but because it's so broad. I mean, as I said before, and this is what happened back in 2001, they would arrest somebody and then they would dig through the file to find something wrong with them. It's as though they were to go, seize somebody for, tax fraud and then go through all your tax returns to find something you didn't say right sometime in your life. And my guess is that they could find something for most people. And, that was what they did. And so they would find the person who hadn't kept up the number of credits that they're as a student, or, hadn't given their change of address or whatever. And those kinds of things were used back in 2001. And as long as the system is as expansive as it is, and there isn't a system of really allowing people to have a fair chance at bond, that can happen any time. And I think we have to be ready for it to happen again. So. Other questions? Yeah. Yes, please do.
I've heard the Immigration and Customs Enforcement officers say that they have the broadest law enforcement powers of any federal law enforcement agency. And the reason for that stems from their ability under the statute to enter houses, enter board vessels, question people about immigration status with a lack of restraints that would apply to most law enforcement. And the Supreme Court case on that was either Mendoza-Lopez or Lopez-Mendoza, I can never remember which said that an individual can be detained, and that's the critical element. Before you get to detention is apprehension. That an individual can be apprehended based upon an entry into premises without a search warrant, and based upon questioning, irrespective of the Fifth Amendment, based on this sort of, and further, that the court will not apply an exclusionary rule to restrict law enforcement conduct in this kind of an operation. Is there?
Yes.
Well, you can talk about that.
Sure,
Because it's
sure.
bizarre to me.
Yeah.
And then let us know if there's any effort to attack it.
Yes, in our clinic right now. So the case is Lopez-Mendoza, which said that the exclusionary rule, which you're all familiar with from watching Law and Order or anything else like that, is says that with police generally, that if they don't follow certain rules, evidence won't be allowed to be used in their case. So Lopez-Mendoza, the question was, well, if you have immigration officers who don't follow the rules, what happens? And the court said, well, we don't want people to stay here in the country where it's unlawful, and so they did not allow the use of the exclusionary rule in that case, but they said certain things which have been the basis for future litigation. So one is that they said that where there's a widespread pattern of violations, that one can apply the exclusionary rule or might be able to, and the other is when the violations are egregious. So, it's scary to hear you say that you've heard ICE officers say they can enter people's houses without a search warrant, because that actually is one of the few things where they've acted that way, but they have then pretended that they didn't act that way, and they've gotten caught. The official position in the last administration was that when an ICE officer goes to a house, they are executing an administrative warrant. An administrative warrant isn't like a criminal warrant. A criminal warrant is signed by a judge. An administrative warrant is just signed by the next guy over on with the next desk in the immigration bureaucracy. And so the government said that they could only go into people's homes with consent. Now, there are a lot of reports that show that there was purported consent and there was no consent, and that's been the basis of a lot of litigation. We, for example, in our clinic are litigating a case involving somebody who was arrested in his home in the middle of the night in New Jersey when the officers were coming looking for somebody who was supposed to have also lived in that house. And there was the claim that there was consent, and we say there was no consent, and that's part of what we're litigating. And there is a lot of evidence of widespread violations with those operations, and so there's a little bit more of a case. And some of those cases have succeeded, some have not succeeded. It's hard to win those cases within the agency, but ultimately some of those cases go to the courts, and some courts are respecting those. The other thing is just trying to monitor what's happening. So, for example, on the question of boarding trains, which is something we've paid attention to because we represent somebody who was arrested on a train, the government makes the same claim. They claim that when they go through the train, with a uniform on that says Customs and Border Patrol, a gun, and an officer in the front and the officer in the behind, and they walk through and they say, "Are you a citizen?" and show me your documents and questions like that. They say it's consensual. People don't feel like it's consensual. We're actually trying to figure out how can we test this. Can we get citizens to refuse to answer and, see what happens? And it's, we're so worried about what's going to happen to people if they actually do that, and so it's a very scary thing to be up against an officer who's got that power of the law. But one can try to prove that these encounters are not consensual. We believe that with our client it wasn't consensual. You can try to prove that what's going on is racial profiling. With respect to our client, we think so. We've seen, there are other cases where people talk about very clear racial profiling. Racial profiling is recognized as an egregious violation, so that's something else that can be litigated. These are hard cases. They're not cases that your ordinary immigration lawyer is going to be able to do because they're expensive to litigate. But it is the kind of thing that law clinics can do and other institutions, and there are quite a number of us who are doing it, with more or less success in different parts of the country. So there are things that can be done, but Lopez Mendoza remains a huge, huge problem, but not one that I think is completely insurmountable. Yeah?
Shamefully, I don't know enough details about the Patriot Act, but are there any aspects of the Patriot Act through which this endgame deportation is facilitated?
Well, it's actually a very interesting thing because people in the general public often think it was the Patriot Act and other measures post 9/11 which made things so bad. And in some ways, that's true at an enforcement level. I mean, there has been a doubling of deportations since 2001, even though there had been such a huge increase. I mean, a tripling going up to 2001, from like 1994 or so. But 2001 is certainly an important year in terms of a lot of these mechanisms. But the Patriot Act itself, I believe, is the place where this provision is that we were talking about before, the preventive detention provision, but the one that hasn't actually been used. So what's actually being used are things that, in some cases, the Bush administration tried to get from Congress. They didn't get from Congress, so they figured out ways to do it administratively through the immigration system. And so it's not actually the statute that's the problem, although it is, the set of regulations, many of which were put in place by Ashcroft at that time. So probably take one more question, but you don't have to. Yeah. So yes? Yeah. Yeah.
Okay, so it's my understanding that the incentive structure is really heavily stacked against trying to secure legal documentation. That if you, that it's impossible to take a really long time, even if you submit your petition, you can spend 8 years and actually be technically legal again. And I'm wondering what your anecdotal experience has been, clients who've made a rational thinking decision not to upgrade their papers because saying that they need to upgrade their papers can be explicit.
Yeah, well, there are a lot of perverse incentives in the 1996 law. One of them is that, there's this rule on unlawful presence. This is probably the biggest problem. So that people who have been in the United States without lawful presence for 12 months, if they cross the border, if they go anywhere, then they're barred from coming back for 10 years. And so people don't want to face that, and most routes to status require that you leave the country to go and pick up documents at a consulate. So there really is no there. There isn't a route. There isn't a line for people to get on for most people. So, some people can seek status. I think what people are sometimes advised by lawyers even is that if they wait, let's say somebody who's married to a permanent resident, if they wait till the permanent resident is a citizen, then they can change their status and stay in the United States. But if they apply while the person's a permanent resident, then they will get deported and they won't have relief. So it's a sort of a crazy system. And if it's that person, and they have some children and so on, I mean, they're not going to do that. And so I think there are a lot of perverse incentives, and I think that again, the 3 and 10 year bars were things that weren't really thought through in terms of the bigger consequences that they would have. So. Okay, well, thank you all very much.